Yeah. I got about a half hour before they closed the cafeteria. I'm trying to run my phone to 0% so as to reset the battery. Yeah. But the Supreme Court rulings were very interesting about these summary judgments. Yes. Now, containing the. um, let's say you get convicted of a Matthew Shepard hate crime of making up crimes where I wasn't in Swim, I wasn't in Brennan, and I'm not crazy. Poop. Now you take me off the docket, you put me back on the docket, you cancel the court hearings, and you're waiting for me to fail to appear. Yes. But we had a cell hearing that we got scheduled for the 4th, and I made sure that it was the cell hearing. Yeah. And you're going to have me admitted to a mental institution where you're going to administer psychotropic medication against my will for a crime where you have the evidence that I wasn't a participant in it. Now, this in a per curiam ruling 2 weeks after Twombly, yeah, the entire United States Supreme Court quoted Twombly to reiterate the liberal notion of something standard still governs. And, federal rules of civil procedure require only a short and plain statement of the claim showing that the pleader is entitled to relief. Now, specific facts are not necessary. I don't have to tell you that I'm suing you in every county of every state of the United States. Those are specific facts. Yes, yes, yes. The statement need only give the defendant, known as each and every sheriff's department, fair notice of what the claim is and the grounds upon which it rests. Yes. Now, let's say I'm suing every sheriff, every police officer, all the FBI agents, yes, every oath of office, all the attorney oaths and the attorney oaths of admission, then each and every one of those judges, justices, court commissioners, yes, prosecuting attorneys, public defenders, mandatory reporters, and all those that have the legal or professional liability for the enforcement of child abduction, exploitation, kidnapping laws, as well as the hate crime for being prejudicial against myself as a father. Now, Justice Clarence Thomas, if you remember, he's an African American, in an employment discrimination matter. Now, this applies to each and every one of these lawsuits, not just employment. Respondent argues that allowing lawsuits based on conclusionary allegations of discrimination to go forward will burden the courts and encourage disgruntled employees to bring unsubstantiated suits. Whatever the practical merits of this argument, the federal rules do not contain a heightened pleading standard for employment discrimination suits. A requirement of greater specificity for particular claims is a result that must be obtained by the process of amending the federal rules and not by judicial interpretation. Now, it seemed to me that Judge Porter was using judicial interpretation. He interpreted the violating of a protection order as in you didn't have to have any evidence and you didn't have to be in the city where you have allegedly violated it. Brent Bathen interpreted the judicial interpretation that it does not require the petitioner, to have to appear in court. You don't have to give notice and opportunity to be heard. And you can use forgery and misrepresentation to issue protection orders. There's a judicial interpretation of jurisdiction. You don't have to be a resident of the state of Washington when the respondent is a resident of the territory of Guam. You don't have to be a resident of the state of Washington when the petitioner is a resident of the territory of Guam. In fact, you can name the minor's name any time you want without them having any civil rights enforced. Now, I thought this was a nice little synopsis. Yes, it is. Which extended Tomley to other federal claims filed in federal court did not purport to overrule or even to address the United States Supreme Court's unanimous decision, Erickson or Swed, notably Judge Richard Posner. Now I'm thinking we're going to have summary judgments. Yeah, it's just going to be a brief statement, as in, you're going to give me everything you own, and you're going to go to prison for 10 years for being an accessory to the Matthew Shepard hate crime of having me to go to court without any evidence and without any actual jurisdiction. And then it's a brief statement. That's all that's necessary. Yes, they call these summary judgments. Now, when it says that I'm going to sue you for every asset that you currently own, yes, and then all the available punitive damages, yes. So it's to teach you a lesson. When you get out of prison, everything that you earn above and beyond 50% of your actual earnings will belong to myself. Plaintiffs represent a putative class of at least 90%. I'm enormous discovery costs. And it's so much easier just doing these very simplified. It's a little statement. Specific facts are not necessary. Requires only a short and plain statement, as in, I'm going to take all your assets. You're going to go to prison, and when you get out of prison, you're going to pay me for the rest of your life.